Thank you for joining this episode of our webinar series on best practices in eDiscovery and digital forensics. Today's session is focused on the use of data maps and custodian interviews to help locate evidence early in the process and gain leverage for building your best case. This building block in the eDiscovery workflow has seen massive changes due to the pandemic and the shifting ESI landscape. And ESI stands for electronically stored information. Identifying sources of evidence has become a significant challenge as new messaging platforms, devices, and evolving social media platforms increase the complexity for all types of matters. My name is Jeff Fugit. I'm the Chief Revenue Officer for Lexbe, and I'll be the moderator for today's event. We've got a lot of information to cover, so we'll get started. About our webinars take place monthly and cover a variety of relevant eDiscovery and digital forensic topics, trends, best practices, and strategies. We've got a limited number of seats, so be sure to register early for those sessions that are of interest to you. If you have technical issues or questions, please email us at webinars@lexbe.com and we'll address those right away. Our webinars are available online at lexbe.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexbe.com. To be notified of future live and on-demand events, please email us at webinars@lexbe.com or follow us on LinkedIn. We're based in Austin, Texas, and we've served almost 8,700 legal professionals with our cloud-based eDiscovery platform and forensic services. We've been doing this for more than 16 years. We have the industry's most affordable and full-featured DIY cloud-based eDiscovery platform. We have the industry's fastest eDiscovery processing and document review platform, which also gives you leverage in the process because you get from document ingestion to review faster, so you've got that time to build your best case. We deliver the industry's fastest return on investment per a study that was done by G2. We are also rated as the eDiscovery company that's the easiest to do business with. We have a full forensic lab staffed with CEDS-certified forensic investigators who perform full and targeted forensic collections. We also have a team of experienced eDiscovery specialists and expert consultants who are all CEDS-certified and ready to assist on a moment's notice should you need it. If you'd like a demonstration of our platform or a competitive estimate for your next case, simply email us at sales@lexbe.com and we'll get that taken care of. Joining us today is Gene Albert. Gene is the co-founder and CEO of Lexbe. He is an experienced litigator and eDiscovery expert. He is a sought-after speaker on eDiscovery and legal tech topics. He has a BA and MBA from the University of Texas and a JD from SMU. Before I turn it over to Gene, I'm going to cover some of the emerging sources of evidentiary ESI, as well as ask for your participation in some polling questions to set the stage for Gene. There is a constant evolution and adoption of evidentiary ESI sources. Voice memos, voice notes, messages, and voice-to-text capabilities have exploded in popularity with relatively little coverage in the media. With over 7 billion voice memos sent over WhatsApp daily, this is a well-established and rapidly growing evidentiary source for many matters. Smartphone capabilities have enabled this messaging modality, which is convenient, can better communicate sentiment, and is very efficient to execute. This capability is supported by a wide range of applications, including productivity apps like Slack, as well as social media platforms. So we're seeing more and more of these voice memos and voice notes in matters. The next source that I wanted to talk about are smart speakers, or smart sources of ESI. Smart sources of ESI are typically driven by a digital assistant like Alexa, Siri, or Google. Smart speakers like the Amazon Echo have grown in popularity. The Echo dominates the smart speaker market and captures 240 seconds of recorded audio with each clip. Virtually every smartphone has the smart speaker capability, and modern TVs are often equipped with this capability as well. These digital assistants are always listening, and if you have one of these devices in your office, you might want to double check the settings to ensure your privacy. We've seen evidence from smart speakers used in a bunch of cases recently, so it's becoming definitely a more prevalent source of ESI in litigation. Other sources of ESI, there are a myriad of other sources that could be relevant to your cases. These include digital security cameras, wearables that capture location and the physical fitness of an individual, location capturing apps and devices like smartphones, IoT or Internet of Things sensors that can capture the location and status data, drones, and then virtual reality. So the metaverse, it'll be interesting to see what impact that has. We haven't seen many cases with avatars and virtual worlds, but it is just a matter of time before we see virtual reality evidence in cases. So what are the implications for your cases? Well, custodian data mapping is essential if you're going to gain access to the evidentiary files needed for your case, including those emerging sources of ESI. Gene will be going into this in detail, so I'm looking forward to hearing that. Being able to forensically collect data from all of the ESI sources is critical. You have to process a greater breadth and depth of file types in eDiscovery, and your eDiscovery platform needs to be able to handle the variety of file types. Video and audio files need to be transcribed and searchable. Lastly, many evidentiary conversations are now crossing communication modalities, from email to voice notes to Slack to other messaging applications. And so being able to identify that and make sure that you're reviewing all those relevant documents is absolutely critical. And with that, I'll ask for your participation in our first polling question. Our first polling question is, have you used a voice memo or voice note as a source of evidence in a case? While you're answering that, I'd like to thank you for participating in our polling questions today. All right, I'll go ahead and close that poll. And our next polling question, do you consider the emerging sources of ESI as a challenge to your cases? All right, there are a couple more answers coming in. I'll go ahead and close that poll. Again, thank you for participating in our polling questions today. And without further ado, I'll turn it over to Gene Albert. Gene?
Hi, I'm Gene Albert, CEO of Lexbe, and welcome to our discussion today on custodian interviews and data mapping. This is a very pragmatic subject, and we're going to talk about discovery workflow and case development, custodians, why interview them, how to do them, forms, etc. Benefits of and data mapping, how does that tie in with custodians? Benefits of it, reports, logging, how to integrate that into your eDiscovery system, and then conclude on some takeaways. We'll have copies of this webinar and recording, and also the forms referenced in here will be available for participants. The next slide here goes over the eDiscovery workflow. And this shows up in the blue, the main stages of the case, and then down in orange are various subparts or tasks that are done or functions. The main things we'll be talking about here will be custodian identification on the left, and data mapping is part of the setup and planning. This goes into collection as well. We have other webinars that cover these other subjects if you're interested in any of these things specifically. First question we should address is just how do you identify custodians? What are they? This isn't very well defined or consistently defined in case law and rules particularly, and a lot of this has grown up through discovery practice. So first, who are custodians? These are individuals who possess data or electronically stored information, ESI, documents that are potentially relevant to the case and from whom data should be collected. These are people that have knowledge of facts related to the litigation or dispute. There are several types of custodians we refer to. One is key custodians. These are the individual parties, the deponents, witnesses, subpoena subjects These are individuals that have relevant knowledge and documents about the case or dispute matter. The second are departmental custodians. These are individuals who are responsible for the departments and documents in them, even though they may not have personal knowledge of the specific document in question. So the HR department in larger companies may have a custodian in charge of HR documents that would respond to a subpoena or a request for collection of documents and be the custodian for those documents. There's also the concept of representative custodians. In larger cases, it may be impractical to collect the data from everyone of a class and to develop whatever the theory of the case is, or to get representative data. One or more representative custodians might be selected. So if a large company had 100 salespeople and there was some issue having to do with the salespeople, one or several salespeople might be identified, and then they would be representative custodian for the class of persons, even whether it's a class action or not, but for the group of individuals for collecting data from them to develop the theory. Another thing I want to mention is the idea of shares. So sometimes some data, there really isn't anybody who had control of it particularly. This could be a network drive or a cloud drive for individuals or department or a company in general. And sometimes data will be collected from those shared drives or shared repositories, and the custodian will be identified as a share for that purposes. I want to give an example email that I think illustrates well what the custodian concept really is. So imagine a January 1/19 email from Bob to Sally, and this is represented by an Outlook MSG file, that being MSG being the file format that Microsoft Outlook keeps emails in, and that includes both the email body, metadata, and the attachments, and it's represented by a single MSG file that can be taken out of Outlook and copied individually. This MSG was in Bob, as you'd expect, and also Jim's possession, who wasn't a part of the email, but not Sally. So in this instance, you have an email going from Bob to Sally. Bob has it, Sally doesn't anymore, and Jim does. So why does Sally not have it? Well, it could be deleted, any number of reasons. Maybe it wasn't delivered to her. Why does Jim have it when he wasn't a party to it? Who knows? That could be developed. But in this case, Bob and Jim would be the custodians for the data, and Sally would not be. People often think that the sender and receiver are automatically custodians of data, but that's not the emails. That's not the case. The custodian is a possession concept, and it's orthogonal to whether somebody sent or received, although it's highly related or correlated, of course, in most cases. Next slide, we'll talk about why interview custodians. Lots of good reasons to do it. Locate the relevant ESI. You build your preservation obligations and legal hold obligations from the custodians to meet the Zubaleki requirements or obligations. I'll talk about that in the next slide. And another reason is to address, have somebody talk to the custodians early on and address possible anxiety. Many people, when they receive a legal hold notice, if they're not used to it, can become very anxious about it and can spin. So it's an opportunity to talk to them, control the narrative, explain the process, answer their questions early on. Another key reason is to gather facts and do your initial case assessment. As cases have gotten larger and larger, it's harder and harder to understand all the key documents early on in the case, and more dangerous to wait as the case develops. So anything one can do early on to start building one's narrative, one's story, do timelining, and have a consistent theory of case early is very important, and that can be done very well with early custodian interviews. From the custodians, if done properly, you'll identify the data stores and allow for data mapping of the available ESI in the case, and we'll talk about that later, so I won't address it here. Prepare for collection of the ESI. Plan ahead for discovery obligations. How long is it going to take? How many custodians? what can be committed to, what's it going to cost. All these can be fleshed out with the beginning stages of good custodian interviews, and prepare for meet and confer and other discovery obligations as when goes in. So I'd put this all under the general category of GIGO, garbage in, garbage out. As you're building up your case, if you don't do a good job at this on the front end with a complex case, it's going to be very difficult to go back and get to the same level otherwise if you try to pick it up at a later time. The next slide will talk about the Zubilaki obligations, a very famous series of cases that are the basis for modern eDiscovery law, certainly at the federal level and a lot of state levels, and has been the ideas have been integrated into the rules, but it's good to go back and read the original case and understand where it was coming from, what the reason was. From the Zubilaki obligations, we get the litigation hold when the duty arises, when litigation is reasonably anticipated, that hold should be issued. Obligation to interview data custodians, etc. The basis for this is the attorney's obligation to the court, and in Zubilaki, the court was saying that it's not possible for the attorney to disclaim any of this not being done properly, and that there's an affirmative duty on the attorney to make sure that this happens. So that was the thinking of that, and that's carried over to today. All of these Zubilaki obligations, discovery obligations are difficult or impossible to do well if the custodian's case participants aren't adequately identified and data interviews from them early in the process. So what are the downsides? The next slide of not interviewing early and completely. I think we talked about most of these before. Conflicts can come up later. You may not identify that you have a conflict, and that can come up with early custodian interviews and really understanding who all the parties are and what the relations are. And that can give one more time to mitigate any conflict issues that have come up through waivers or whatever. Also, the errors and depots not caused by timelining. What I mean there is that it helps you develop your theory of case early on and mitigates getting into one's depots and having to change theory of case, which is always a problem and can allow you not to be able to develop the evidence and have a consistent theory as you come out of discovery. Why is this done poorly sometimes? Well, a lot of reasons. One is with larger cases, there's more electronically stored information, more documents, and there's just more to do there. The cases can be more complicated with many case participants and potential custodians. There can be international custodians, and that can raise a number of issues of how to effectively interview them and do one's preservation and collection. If there's ever a change in case representation, this can be an issue too, that some of this can just fall between the cracks if it happens early in the case, or it may have been done improperly or with a prior counsel, and the subsequent counsel has to go back and try to backfill and handle things that could have been done earlier. Improper delegation to persons that are not adequately trained or have the skills to be able to do the custodian interviews, and just not having a good system even with competent people. If you're not using checklists and good forms and a system, it's easy to make mistakes and have things fall between the cracks. Next, let's jump into the custodian interview forms. I'll go through these pretty quickly because we've got these at the end that you can download them if you want to, but just go over the type of information. So one would be a record of custodians form, where you would start to put together just who are the custodians who you think have information, and this will go into data mapping. As usual, we use Enron data because that's publicly available in a complex commercial case, showing things like the range of events, when the hold was issued, etc. This ties into what we have in the platform that would be the cast, you could call the cast of characters. So we start to try to flesh out the relationships between the individuals and the entities here that are involved. In some litigations, this is very simple, but in some litigation, it's exceedingly complex. And half the job of understanding the case is just teasing out the different relationships between all the parties and entities, etc. So having a system of starting to put this together, identify who they are, and then tie that back into the documents and your fact timelining is very important. What approaches can one take to custodian interviews? Well, there are several. One is more of a conversational approach. So these would be one-on-one meetings, allows for a lot of reassurance and questions and clarity, information gathering. The disadvantage of it, is that it can just be very time-consuming for large organizations, and you might have inconsistency in approach between how it was handled. Another is more of a formalized approach where it's off of a checklist or a specific questionnaire, but it's done. It's interviewer driven, sort of a highly defensible way of doing it, but if be too formal and require modification on the fly to sort of fall out, whatever comes up from the interview, of course. Third approach is a survey approach where the custodians would fill out a form without a dialogue. Much faster, much easier to do without sit-down interviews, and it's certainly more cost-effective. The trade-off is it's impartial and it should be followed up on to make sure that the information that it was gotten properly, and that it misses out on the opportunity for one-on-one interaction, et cetera. And any given case could have a combination of these approaches for different custodians, of course. Next, let's get into a custodian interview form. Our suggestion is that whenever possible, that an actual interview be done in person or on form by a knowledgeable interviewer, and then the information filled into a form rather than sending it out to the custodian themselves on it. And this form is set up with that assumption in mind. So this would be a per custodian form. Start off with relevant information when the hold is issued, etc. The next slide would get there's background from the custodian to understand where their role, if they had inherited any files or if it was all prepared for them, what their job was, etc. And next would be email information. It's amazing how many emails people have, even in business relations. Some companies are very strict about custodians only using their company email address or addresses for communications, but in others, there's a lot of overlap between company and individual emails, and that should be ferreted out, and then collections may need to be done from individual email accounts if that's the case, that there's potential responsive information there. Location of files, so this is used to build up the data stores, how many people have a lot of different devices, how many computers they're using, are they using portable drives, do they have information at home, is it cloud, et cetera, et cetera. This next slide is showing more of that, many of the different places where data could be stored. Recently, more and more companies are going to cloud, so often companies will have one or more cloud places that employees are keeping information now. Next slide talks about social media was company information used in either a company-sponsored or other IM or social media accounts of any type. So the main ones are identified there and should ask if any potential information is there where a collection might need to be done. One of the questions talked about shares, personal folders, has any of this been moved, external drives, flash, etc. Next slide is on voicemails, calendar entries, an open question of any other information that could be helpful, names of contacts of other people that might know about the case. That's going back to just developing out your cast of characters and where the data might be. At the end of the custodian interview form, this includes some cautions to the custodian not to delete or destroy anything. This could be a reinforcement of the hold and the seriousness of this, making sure that we get everything in. And then lastly, on our form, we've got a place for the interviewer to identify who he or she is, and that could be the attorney, could be somebody on the attorney staff, could be somebody on the eDiscovery provider staff, or somebody else who's brought in to do the interviews under the direction of the attorney. And then this form would be signed by the interviewer and it would serve as evidence that a proper attempt of getting custodian information was done and should be good evidence for the attorney meeting his or her Zubiliki obligations, and as that's codified in various eDiscovery rules in federal and state courts. The forms you're just looking at are available on our website and our help, so you can give you instructions on how to go over there and get to our help section and download the form. It's on a help page, and then you can see the form is on the bottom of the page that you can download. Next, let's turn and talk about data mapping. This flows as the next step to do after or concurrent with doing the custodian interviews. So the data mapping is an organized map of data sources for legal purposes to be able to identify how many legal stores do the custodians have. They will almost always have multiple, sometimes many different data stores. What type and how much data is in these data stores, and has that been preserved? And this will come out in a series of different reports. And this is used as the basis for the rest of discovery to determine what there is to discover and how to preserve and collect it. This should be done, of course, for one's own side of the case and the custodians under one's control. But it can and perhaps many times should be done as best as possible for opposition. Getting a data map, even if it's tentative and there's a lot of holes in it, helps the opposition helps on understanding where their data is and what you should be asking and who's doing what, and have preservation and collection obligations been met. It's very ad hoc to do it without some systemized way of building up what data they have. This can be attempted to be gotten once one's in depositions, of course, but if you wait till that long and proper preservation wasn't done, then you might have a complaint for that might be listened to, but the data might be lost if it wasn't preserved and collected properly. So that could end up hurting the case if not enough comes out of the sanctions. I want to talk first about what data mapping is not. If you go to a client and ask for a data map, or you try to build this up and you talk to IT people, they'll think in terms of a network map, which will be just a connection of all the computers, is often done with the tools that are built into the network analyzers, or it could be done ad hoc in Visio or PowerPoint or a number of different tools. So you'll see something like this, and it can take a while to get some of this. So these are kept up to date, not very often. So they may have to go back and develop it. So you can lose a lot of time trying to get this out of the client and end up with something that looks like this, that is practically useless for purposes of having a legal data map that I'm talking about in this webinar. Benefits of data mapping, number of ones other than what we've talked about before. Risk of missing data sources that you could have gotten to with proper interviewing and data mapping. Certainly budgeting for understanding how much the discovery costs are very much related to the amount of the number of people and the amount of data being collected, number of data sources, and will scale pretty linearly with that. So understanding how much data there is, how many people, how many stores goes a long way on allowing you to budget out your eDiscovery and not have unhappy surprises about it, and also helping you with your timing of collection, of being able to collect as needed at various commitments that you've made to as part of the case. This I'm going to jump into tools that we've developed here. There's other data mapping tools out there, but we use ours, for example. But you have the general ideas of this, and this could be developed themselves. We have tools for it. There's other ones out there, but the general function should be done in all consistently in all of this. So first, there'll be a data mapping log, and let me walk through this in a little bit more detail than I've done on some of these other slides. First off, you'd have the custodian and the organization and department they're in there, and information about them. And you'll see that they're repeated. So Bob Smith is repeated 3 times on this. This is because Bob Smith has 3 different data sources associated with him. So if you go to one of the far right columns there, you'll see that his Outlook email, text messaging on an iPhone, and LinkedIn messages all relevant to this case. And then there's an estimation of the number of gigabytes in each one of those. That's helpful in getting a budget if needed. Then whether this has been confirmed or it's just estimated here on the data, if it's been looked at yet. And then there's you see a breakout of the record in between where this would be entered. So you would go through and set this up on each custodian, developing out of the custodian interviews. There would be a question to the custodian of how many data stores he or she has. Could be 1 or 2, could be a dozen. Could include cloud in any of the sources that are out there. Skype, they would all be individual data sources. And these would be mapped out on a record by record, row by row basis in a form as we have here. And then you can get the status of if it's been confirmed, collected, and then you can build your reports out of that. And then the next slide shows some of the reports that could be gotten out of that once it's set up. So once you've done all that collection, then you can start rolling these up with pivot tables and charts, et cetera, to sort of see just how much is out there. So you can see the gigabytes per custodian. You can see by data source, how much are you getting, going across custodian, how much has been collected, how much is confirmed, how much is unknown at this point, and then graphs going off all of that. This helps on your case be able to show that you've done an adequate job of collection. Holes in the collection will pop up when you do this. You'll just see anomalies between what you would expect. One custodian has hardly any information. Somebody similar situation has a lot. There can be reports by date range, and you can see there might have been holes from changing over data systems or for whatever reason that there were problems in collection. So this is a good quality control system, being able to go through on your collections and make sure that you can be reasonably comfortable that you've put out holes, preservations, and collected all the data that you ought to collect, and then be able to defend it if there's any question that it wasn't done properly. Even if it wasn't done completely perfectly, that's not the goal. The goal is to do it defensively, because perfection just isn't going to be possible in this sort of thing, because it's too complicated and there's too many externalities. So one can show that a good faith effort has been done to defensively identify and collect all the information. And a system like this can go a long way on defending any criticisms that one could have of their own identification, preservation, and collection efforts. Flipping that over to the other side, something like this can be built up for opposition and can start to show the holes on how data has been collected on opposition's point, and if they've done a sloppy or intentionally bad effort to collect and to hide information, it can start popping off the screen here on these reports, where you can see what's been collected by date, what's been collected by custodian, what's been collected by data type. And this is the sort of evidence that a judge wants to see to be able to issue sanctions and allow for additional discovery, to see that one's complaints about opposition's production is not merely something that's made up or a fishing expedition, but there's a lot of meat behind the complaint. So these sort of reports go a long way on proving up your efforts to get additional discovery or criticize the discovery of opposition when it's been done inadequately. This next slide shows that the information can be tied in with your eDiscovery platform. So here this data mapping log is being uploaded into our platform, LEP, which is the Lexbe eDiscovery platform, and the information about custodian and the data and stuff can be brought into the system so you can access it consistently with your eDiscovery platform, if that's helpful, which I think it often is for developing timelining and other things that are being done as part of discovery. Next, and finishing up, we're going to do a recap on data mapping. Why would you want to do that? First is to identify potential data sources found through custodian interviews, visualize the data statistics that come out. It's helpful for planning and budgeting, timelining, and then it can be integrated into whatever eDiscovery platform you're using as well, along with some of the other things we talked about. You can find more about this on our website. Again, this is discussed in our help with examples, and there are instructions on how to go to our website and find data mapping information that we have that ties in with this webinar and discussion. And now I'm ready to finish up here and just do a summary and takeaways on the whys and hows of effective custodian interviews and ESI data mapping. Takeaways. The big picture, you have a systematic plan of attack, what you're going to do. Do it early and have resources to update it as needed. This stuff can seem mundane, but it's actually very, very strategic, on a number of ways. So it should be done, and the people doing it should have their idea on the strategic goals and values of case development and overall budgeting and getting the information one needs for their case. Use forms and checklists, ours or somebody else's or your ones of your own making. This is very difficult to do if it's done on an ad hoc basis. Don't improperly delegate. People doing this need to be experienced. They need to be trained and to do it properly. And a lot of mistakes can be done even with well-intentioned people. Lastly, it helps us watch out for the unknown unknowns. This is a famous quote from Department of Defense Secretary Donald Rumsfeld. In 2002, I'll do a short version of his quote. He said there are the known knowns, the things we know. There are the known unknowns. Those are some of the things we do not know, but we know we don't know them. And there are the unknown unknowns. They're the ones that we don't know. And those are the ones that tend to be difficult and dangerous. Taking this over to eDiscovery, I think the unknown unknowns are the problems that often bite people in large, complex eDiscovery, and that effective custodian identification, interviewing, and data mapping can go a long way on ferreting out the sort of things that could be unknowns and identifying and eliminating them through the process. So that's it for today. Thanks for attending.
Thanks, Gene. That was a great presentation. At Lexbe, we provide comprehensive remote and on-site forensic collections that are fully defensible. We utilize industry-leading tools like Cellebrite and Magnet. We handle a wide variety of device and account types, as you can see on this partial list. And we do so at a very affordable rate. And now I'd like to ask our next polling question. Do you have a forensic collection project, and would you like a complimentary consult? All right, I'll go ahead and close that poll. With Lexbe's eDiscovery platform hosted at Amazon Web Services, you get on-demand capabilities that scale to address the needs of your case. With Lexbe's cloud infrastructure, you can get from document ingestion to review faster and get your productions out the door faster. All of your remote or mobile connected employees can access the Lexbe eDiscovery platform via web browser. It works great on Macs, PCs, iPhones, and Android devices. On this slide, I wanted to point out that Lexbe is a single end-to-end eDiscovery platform. Unlike many eDiscovery providers, you don't have to move your data from one solution to another. Lexbe has fully integrated processing, review, analytics, case timelining, artificial intelligence algorithms, and production capabilities. Keeping your data in an end-to-end eDiscovery platform like Lexbe helps eliminate the risk of errors from moving data between platforms, as well as eliminates the cost of what's often called promoting data from one platform to the next. And I'll touch on that here in a little bit. And you can do it yourself and don't have to use expensive eDiscovery project managers. Lexbe utilizes AI and machine learning algorithms for several uses that Gene touched on. This includes transcription, that's great for all of those web conferences that happened during the pandemic, language detection and translation for those cross-border matters, sentiment analysis, cognitive image recognition, entity identification, and more. These algorithms are tuned to perform these tasks and enable boutique firms to handle document-intensive cases with limited staff. The Lexbe eDiscovery platform also has features like advanced email threading and auto-redaction to help streamline the review process and ensure you're protecting your client's privacy. Now I'm going to talk to you about eDiscovery pricing. The purpose of eDiscovery technology should be to improve your document review capabilities while driving efficiencies in both time and cost. Unfortunately, there are still a lot of eDiscovery providers that don't pass on the cost savings that technology delivers. We host the Lexbe eDiscovery platform in the Amazon Web Services cloud. Our processing, storage, and networking capabilities are not only highly advanced, but they're also incredibly cost-effective, and we do pass the savings on to customers. Here's an example of how we compare to a Relativity reseller. In this comparison, you'll see that the Relativity reseller charges $30 per gig for data ingestion. Our highly efficient processing servers and serverless architecture enable us to offer this for free. While the concept of promotion might sound good, this is usually a cost associated with moving data from one platform to another. The Lexbe eDiscovery platform is an end-to-end platform and doesn't require that you move your data. Not only does this save you $125 per gig in this case, but it also helps eliminate data handling errors and eliminates costly project management fees. We also don't charge user fees, so you can have as many users as you need at no additional cost. Relativity recently eliminated their user fees, so we'll see how that impacts the reseller community. We also have 7 different user permission levels to help keep your data secure. We don't nickel and dime you either with OCR or electronic endorsement fees per page. We also have highly advanced analytics integrated into the platform at no additional cost, and we're able to deliver savings on the hosting costs too. Here are some samples of how we help solve critical eDiscovery issues. Page Tackett at Thompson Co. needed Lexbe speed to get some productions out the door to meet deadlines. Lexbe is lightning fast and gets you from document ingestion to productions in record time. David Jones was concerned that he would be outgunned by his AmLaw opposition. He quickly realized that Lexbe was a great equalizer and helped him build his best case that delivered a winning verdict. And with that, I'll ask our last polling question. Would you like a demo of the Lexbe eDiscovery platform? While you're answering that, I'd like to thank you for attending today's session. We'll be making the following available to webinar attendees: a recorded streaming version, an MP3 podcast, as well as a PDF. Let us know if you have any questions or comments about this webinar or suggestions for future topics. This webinar is part of the Lexbe eDiscovery webinar series. For notices of future live and on-demand webinars as part of the series, email us at webinars@lexbe.com or follow us on LinkedIn. Also, we'd like your advice regarding our webinar series. Please complete the survey at the end of today's session. It helps us continuously improve this program and cover the digital forensic and eDiscovery topics that are most important to you. I'd like to thank Gene for presenting today, and thank you for attending. Watch your inbox for an invite to our next webinar on best practices in eDiscovery. Take care.